Good afternoon. Welcome to this webinar from Taylor Walton Solicitors. My name is Alec Colson. I'm Head of Employment at Taylor Walton, and the theme for this afternoon's webinar is Redundancy, What Employers Need to Know. I'm going to share with you some slides I've prepared, which will appear on the screen shortly. What we're going to do this afternoon is cover sort of the essentials of redundancy. So we'll be covering the meaning of redundancy, and as you will see shortly, the redundancy has a statutory meaning under the Employment Rights Act. We will then go on to discuss individual and collective consultation. When collective consultation with representatives of the workforce is required. We'll then go on to discuss the importance of meaningful consultation and going through the stages of consultation and what should be covered during that process. We'll then discuss selection criteria and some practical tips of how to conduct a redundancy exercise. And finally, I just want to touch upon, for a short period, fire and rehire draft code of conduct, which the government has released earlier this year. So let's move on. First of all, the meaning of redundancy. As I say, it has a statutory meaning, and there are really four types of redundancy situation. Firstly, perhaps the most obvious one, is the closure of business. So where the business actually closes down, for whether it's through insolvency, going into administration, or just simply closes. And in those circumstances, a redundancy situation is likely to arise. Unless there's some form of transfer, of course, under the transfer undertaking regulations. But for our purposes, if the business closes, then that will, and doesn't continue on in any form, that will amount to a redundancy situation. There's also closure of the workplace. For example, where if the business owns a number of branches and it decides to close its Bristol branch, then that will be a closure of that particular workplace, and there may be other branches which will continue, but that will still amount to a redundancy situation. Now, probably the most commonest form of redundancy is where there perhaps a downturn in business or effects of new technology, which means there's a diminishing need to do a particular kind of work. So if there are, for the sake of argument, 10 widget makers, and the company, because of a downturn or because of new technology, there's only a requirement for 5, therefore there'll be 5 redundancies. That's a diminishing need for a particular kind of work. And continue with that analogy of your 10 widget makers and 5 only required in a particular workplace. So there's only 5 required in our example of the Bristol workplace. Then that would again amount to a diminishing need for a particular kind of work, i.e. widget making, and therefore there's only a requirement for a certain number. Say in our example, that would be 5. So they are the 4 areas of redundancy, and if an employer is contemplating making redundancies, then it's required to meet one of those statutory requirements, or at least one. So generally speaking, it's likely to be the third one there, diminishing need to do a particular kind of work. And as you can see, redundancy is a potential fair reason for dismissal. So along with the other 5 reasons for fair reason of dismissal, redundancy is one which the employer can rely upon and say it's a fair reason on the grounds of redundancy. So moving on, what does the employer have to do in order to establish a redundancy situation exists? Well, it may be that there's, as I've mentioned before, an economic case for reduction in the workforce, a downturn in the market conditions. No longer there is a requirement for the number of current employees undertaking a particular kind of work because there's a downturn in the economy, recession, etc. Or it could be not an economic case, or it could be the impact of new technology. So what the employer has to do is to establish whether there's an economic case, why has a redundancy situation arisen, what has been the change in the business. The business needs to identify the change, and that will then lead on to what has ceased or diminished or expected to cease or diminish in the future. If it appears that there's going to be a lack of orders in the next quarter, then in order to preserve the profitability of the company, then that might, in those circumstances, lead to a redundancy situation. There may be other measures which the company can take into account, but for example, reducing other areas in the business. But generally speaking, if there is a diminishing need, then that clearly will meet your redundancy definition. So the way in which the law has written is that once the employer has established its economic case or its reasons that there's a redundancy situation arisen, it is then required to go to the staff affected by that redundancy on the basis that there is a redundancy proposal, and staff are informed that they are at risk of redundancy, and that risk letters are sent out to the staff affected. Now, and that brings us to the next point, which is consultation and the importance of consultation. What the law requires is that it's important that the employer consults with the staff affected by the redundancy proposals. And generally speaking, there are two forms of consultation. The first is an individual consultation, the name speaks for itself, or there is a requirement, what is known as collective consultation. Collective consultation is required where the employer is proposing to dismiss as redundant 20 or more employees at one establishment within 90 days or less. And in those circumstances, the employer is required to consult about the proposed dismissals with the appropriate representatives. This falls within what is known as Section 188 of the Trade Union and Labour Relations Consolidation Act, or TOLRA, where it sets out the requirements for collective consultation. And where an employer is proposing to dismiss 20 or more employees within 90 days, it is required to complete what is known as a HR1 form, which is a government form, which the employer is required to complete and send to the statutory authority, setting out what the proposals are, and so it only applies if there's 20 or more. The form is, if you Google HR1 form, you'll see the form required to complete, and that should be done as soon as possible when it's known that there is going to be likelihood of 20 or more redundancies. So what should collective consultation consist of, and when should it commence? First of all, it should be in good time before the redundancy take effect, And the time limits for consultations for 100 or more employees at one establishment within a 90-day consultation period must begin at least 45 days before the first dismissal takes effect. So if it's 100 or more, the consultation period is 45 days with the appropriate representatives. Where the employer is proposing to dismiss between 20 and 99 in the 90-day period, it should be at least 30 days before the first dismissal takes effect. And often it is good practice that in circumstances where the employer knows in advance that there's going to be a requirement for collective redundancies, so it's collective consultation, the periods can start before the 30 days or 45 days. And I say it's good practice to follow that and let employees know in advance that redundancies are unfortunately a possibility, and that their proposals are coming forward. Under the collective consultation arrangements, the employer must consult appropriate representatives of the affected employees. Now, you'll see in the slide there that the collective consultation is only required where there are 100 or more employees or 20 to 99 employees at, and I emphasize, one establishment. The question is, what does one establishment mean? Now, the leading case on this, and that's why I put it in bracket there, think Woolworths, is the case of the employees against Woolworths, which looked at this question as to what has constituted one establishment. In this particular case, a number of Woolworths stores were due to close, so it was a closure of the business, therefore it was a redundancy situation. And the question was, did you look at the store, all the stores who were due to be closed, or was one establishment just one store? And the court held that it was the establishment was one store. So obviously, in some of those stores, there were fewer than 20 staff, and therefore the collective consultation arrangements did not apply, and that the company could consult with just one, just with individuals rather than on a collective basis. So it's important to, when you're considering collective consultation, is it at one establishment or is it several? And there may be ways of avoiding collective consultation if the establishment has fewer than 20 staff. For those who think that you can get around these rules by, say, for example, putting at risk 19 staff for a period of 90 days, and then followed by a further 19 over the next 90 days, the Trade Union Labour Relations Act recognised that this could happen, and there's a provision there where if the employer is trying to gerrymander the arrangements, then that can still result in a breach of the collective consultation regulations. So, identifying appropriate representatives. Basically, there are three types of representatives: those which are recognised by the trade union, are representatives of a recognised trade union. Those there's the directly elected representatives from the staff affected, or there may be an existing standing body of elected representatives, for example, a staff council. In most cases where there's not a recognised union, it will be directly elected representatives from the staff affected by the proposals put forward by the employer. And this can be a bit of a palaver. the law requires that the representatives are representative of the staff affected by the redundancy proposals. So it's important that your representatives can be seen to be drawn from a pool of staff who are affected by the proposals. And so if you're looking, for example, there may be, say, 30 staff at risk of redundancy, you would need to make sure that there is a cross-section of representatives for those staff. And if they are in different parts of the business or different constituencies, if you put it that way, you need to ensure that, say, for example, if you're looking at looking to make sales staff and secretaries redundant, that those representative groups, those groups are represented as part of the collective consultation arrangements. And in these circumstances, the employer is required to consult with those directly elected representatives. Now, if there are more representatives than required, then the employer is required to hold an election to ensure that to elect those representatives for the staff. And okay, that is a bit of a palaver. So if, for example, you are looking for 6 representatives, and let's say 8 members of staff are nominated as representatives, then strictly speaking, you should then hold an election to determine the 6. On a practical note, I've tended to advise employers to perhaps extend the number of representatives for the sake of 2 and avoid the need for an election. But quite clearly, if you're looking for 6 reps and you end up with 20 nominations, then you're probably going to have an election. So it can be time consuming, but it's important to from the very outset to plan ahead what your process is in terms of getting the representatives elected or in place. Just by way of a reminder, really, or if you're not aware of this, is that the obligation to collectively consult doesn't just apply to a redundancy situation. It also applies where an employer is proposing to change terms and conditions of employment for 20 employees or more by termination or re-engagement. Termination and re-engagement. So for the sake of argument, if the employer puts forward a proposal to change terms and conditions of service, say, for example, changes to pay arrangements or annual leave, or a package of measures, and the employees don't agree with that, or there's opposition to that, then before you can go ahead and dismiss the staff and re-engage them, a so-called fire and rehire, there is a requirement to collectively consult in the same way as you would for a redundancy situation. So the collective consultation arrangements don't just apply to redundancy, but they also apply to changing terms and conditions of employment. And a failure to comply with collective consultation arrangements can be a hefty one. It's a maximum of 90 days gross pay for each employee made redundant for a failure to collectively consult, plus potential unfair dismissal award on top of that as well. So it is important to get this right and have a plan in place where there's going to be 20 or more employees. So what I would recommend to clients is that they set out a timetable to follow where this will apply. So we then come on to individual consultation. So as we've seen, where there's 20 or more, there's a responsibility to consult with elected representatives. Now, where there are fewer than 20 employees, there is still a requirement to have meaningful consultation. And there's no minimum period, as there is with collective consultation, but I would recommend that the consultation period is at least 2 weeks, normally, say, 3 consultation meetings, one to explain the proposal to the employee, another one for the employee to have an opportunity to respond to the proposal with perhaps alternative suggestions, and a third one, a sort of a roundup one, or if there's anything further to add before the decision is taken to dismiss on the grounds of redundancy. Now, the other part of consultation, there may be other things to consult about. Where there is say, for example, going back to my example of 10 widget makers, you only require 5. Therefore, there's going to be need a selection criteria. I shall come on to that in a moment, but it's always good practice, in my view, to consult about the selection criteria, because individuals may have particular concerns about what the selection criteria is going to be used, and in those circumstances, it's recommended that the selection criteria is part of the consultation process. I say we'll come on to that in a moment. And also, the purpose of the consultation is to see whether redundancy can be avoided, and there is a duty on the employer to try to mitigate the effects of the redundancy proposal. So that means proposing, perhaps the employee proposes an alternative to redundancy. For example, a reduction in hours. If they're trying to say they may be willing to work on a part-time basis, or some other working arrangement. But what's the fundamental principle is that the employee should be allowed to put forward any alternative suggestions, and they should be considered by the employer in order to determine whether or not the redundancy could be avoided. Now, the employer is not required to create alternative employment, in the sense that would defeat the object of the redundancy process. But if there are vacancies available, then they should be notified to the employee that there are other jobs, maybe other jobs available. Please also note that there is special protection offered to employees on maternity leave, adoption leave, and shared parental leave regarding alternative employment. Now, this is an area where some employers can make a big mistake, because unusually in redundancy and alternative and suitable alternative employment, if there is suitable alternative employment for an employee on maternity leave or adoption or shared parental leave, they take priority over other employees. So if you have a situation where there is suitable alternative employment for the employees at risk of redundancy, then the person on maternity leave or adoption or shared parental leave has priority. So in effect, there is positive discrimination for individuals in those circumstances. And I have known employers come a bit of a cropper on this for failing to recognise that. Now, this is going to be further complicated in that the Parliament has recently passed the Protection from Redundancy, Pregnancy and Family Leave Act 2023, which is likely to come into effect either later this year or next year, which will provide greater protection for individuals returning from family leave. It will only this preferential treatment won't only apply during the actual leave itself, but for a period of time after the leave, so on their return to work. The full details of that are still yet to be known, but it's something for you to watch out for. So moving on, selection criteria. The selection criteria should be objective, and where posts are pulled, usually using an assessment form with the criteria and a scoring system against that against the criteria. So here I've given some examples of criteria: length of service, performance and skills, experience, attendance, disciplinary record. There are others you can use, but these are the general ones which are followed, and it's for the so where we have, going back to my example of 10 widget makers, we only require 5. So you would assess each of those employees against a scoring system, which can be weighted. So a greater emphasis could be put on performance and skills, experience, and to a certain extent that will be subjective, but it's an objective criteria in itself. But the employee is providing an assessment of the individuals. Now, if you have an appraisal system in place, that may be used to assess performance and skills. But if not, then it's basically based on the knowledge of the individual manager who are doing the skills assessment. And my recommendation would be that perhaps there should be at least 2 scorers, and they score separately, and we show that an objective score has been made. What you can't do is, and in the past, the employer has often used last in, first out. That is now outdated as the sole criteria, as it's potentially discrimination on grounds of age and indeed of sex. But what the courts have said is that it is possible to use it as a tiebreaker in the event that the scores are the same, and that may be used in that way. The individuals are entitled to see their score, but not entitled to see the scores of other employees, unless the other employees give their consent to that. But the general principle is that the employee can see their own score. And this is an area which obviously can cause a great deal of stress and claims of unfairness and discrimination. So it is important that this is carried out as carefully as possible. So, some practical tips. First of all, there's no legal requirement, but it is good practice to allow individuals to be accompanied by a work colleague or a trade union representative in redundancy meetings. The focus should be on the role, not the individual. This is not about the performance or conduct of the individual concerned. It's about their role and the requirement for their role. Don't dismiss alternative proposals out of hand. So if an employee comes forward and say, for the sake of argument, they wish to reduce their hours, then at least give that some thought. Don't just dismiss it. It may be sensible that if, and I've seen this happen in practice, where the employee comes forward with alternative proposals, my advice is usually to take that away, think about it, and then come back with a response, rather than to say, well, no, that's not going to work. You know, the purpose of the consultation, in order for it to be meaningful, is that alternatives are considered. Because what the law requires is that the employer is required to, as a duty to mitigate the effects of the redundancy. Also, don't rush. It's better to take time with the consultation and reduce the risk of an employment tribunal claim for failure to consult properly. So yes, just think about it's meaningful. It's got to be meaningful, not just presented as a fait accompli. Good practice to allow a right of appeal against dismissal. So if someone is found to be made redundant, allow them the opportunity to appeal that decision. And most importantly, keep a paper trail. Keep a note of all the meetings you've had with the employee, the details of that. Likewise, with collective consultation, keep a note of all the meetings. So if your actions are called into question and an individual brings an unfair dismissal claim, you can point to the tribunal that you've gone through a fair and meaningful process. As I mentioned earlier, don't be seen to be in a rush to get it over with. I have seen examples where an employee called to a meeting, said, "Look, we're thinking of making you redundant. Have you anything to say?" No, and fine, and go ahead and dismiss. That's clearly not meaningful consultation, and this is an area where tribunals will look very carefully to see that there has been proper consultation. So, take your time, think it through, be seen to be not be reasonable, but seen to be reasonable, and that you have given it some thought. And do remember that the person who you are consulting with is facing the prospect of losing their job. So that also needs to be, the employer needs to be cognizant of that fact, and therefore it's not the individual's fault. We're not talking about conduct or performance here. We're talking about the fact that a business may be going through a downturn and having to unfortunately make redundancies. If the employee wants to know what they will receive by way of redundancy payment from the outset, then that's fine. I'm always quite cautious of not being seen to rush to a decision, and that the redundancy pays. This is what the redundancy pay will be, because it sort of undermines the position that we're in a consultation process. In my experience, individuals might come in and say, "Well, okay, I'm being made redundant. What am I going to be paid?" And that's a type position to take place, an entirely reasonable thing to say. Whereas another employee might take great umbrage and say, "Well, hang on a minute, I think this is not right. This is not fair. Why are you picking on my job?" And therefore, probably not at that point desirable to start discussing how much they're going to be paid when they're made redundant. So it's a one to be careful with, in my view. Here, the redundancy pay, there's a statutory formula to follow based on age and length of service, which is easy to find. Now, if the employer wishes to make an enhanced payment, enhanced redundancy payment, then it is generally recommended that the employee should be subject to signing a settlement agreement. What you don't want to find is you pay an enhanced redundancy payment, and then the employee brings an employment tribunal claim in any event. So just be careful and sensitive on that particular one. So, fire and rehire statutory code of practice. This is expected to come into force later this year. It follows the dismissal of nearly 800 employees by P&O Ferries, which hit the headlines 12 months or so ago. And in response to that, the government has put forward a proposed new statutory code. And In fact, P&O Ferry wasn't fire and rehire; it was simply fire and replace with foreign workers. But this fire and rehire has sort of become a common phrase now. But it's always been around that where the employer decides that they wish to change terms and conditions of service, and if agreement couldn't be reached, they are dismissed, and the employees are re-engaged on the new terms. And the code does not make that unlawful. But what it does do, and what it reinforces, really, is what we've been talking about. The most appropriate approach is consultation, negotiation with a view to try and reach an agreement, and not threats of dismissal. So that aspect hasn't changed. That's always been the proper approach. What is new is where the employer fails to comply with the code, the employment tribunal has the ability to increase the compensation by up to 25% for each employee affected. And as I say, the code is expected to come at the end of the year. So moving on, any questions? I have a couple of questions here. One is, what should be included in the at-risk letter? So this is, remember, this is the letter setting out, notifying the employee that they are at risk of redundancy. And what I would normally put in there is an indication of the reason for the redundancy. So you have a written record from the outset of what the proposal is, and that is subject to consultation with, in the case of a collective consultation with the representatives, or on an individual basis, that there will be a consultation process, and that they're invited to a meeting to discuss it. So you've got that paper trail, and that if they wish to be accompanied by either a work colleague or a trade union representative, that will be allowed. So it's important just to set out what that proposal is. The other question I have relates to pooling. Now, this is a difficult area. I use a very simple example of 10 widget makers and the requirement only for 5. Well, often in reality, the people may have different job titles, but often doing the same or similar role. And what the law basically says here, that the employer is required to put their mind to the question of pooling. So if there is, say, for example, people doing similar jobs, maybe have different job titles, what the employer is legally required to do in those circumstances is to consider whether those jobs should be pooled. And there may be very good reasons not to pool, but there may be other reasons, well, that there actually are very similar roles, and it would be unfair to not pool them. So the position there then is to think about the nature of the people at risk of redundancy. Are there other people who should be at risk of redundancy because they're part of the same pool? And then in those circumstances, make a decision on what your pool is. So there may be some objections. In a sense, your consultation process may say that one of the results of that is that the pool is actually widened. So again, that underlies the importance of the consultation process. I don't have any further questions. If you would like to contact me, I am there are my contact details there, and telephone number and email address. And I just stop the share of the slides. And may I take this opportunity to thank you for watching this webinar from Taylor Walton Solicitors. And if you have any queries, please get in contact with me. I'll do my best to help you in those circumstances. And thank you for watching, and have a good afternoon. Goodbye.